Hello everyone. In this set of presentations, an attempt would be made to explain the general principles pertaining to law of contract. Now, what is a contract? A contract is an agreement made between two parties and is enforceable by law. Now, what is an agreement? It is a promise or set of promises forming consideration to each other. Thus, in order to constitute an agreement, there has to be an offer or proposal made by one party to the other party, which has to be accepted by the other party. An offer or proposal, when accepted, becomes a promise. Every promise or set of promises is an agreement, and therefore an agreement is an accepted proposal or offer. Therefore, agreement is equal to offer plus acceptance. But every agreement is not a contract. Only those agreements which are enforceable by law are contracts. Social and domestic agreements are not enforceable by law. For example, when A invites B for dinner, B accepts but fails to turn up. Is there a breach of contract? No, because there was no intention on the part of A or B to create legal relations, and it was just a social agreement, not enforceable by law. Hence, it is not a contract. Contract, therefore, is equal to agreement plus enforceability at law. Hence, all agreements are not contracts, but all contracts are agreements. The parties must have agreed upon the subject matter of the contract in the same sense and at the same time, which is called consensus ad idem. The law of contract is that branch of law which decides the circumstances under which promises made by parties to the contract can be enforced. It consists of limits subject to which parties may create rights and duties which will be enforced by law. So far as India is concerned, the Indian Contract Act deals with the law relating to contracts. It deals with general principles which are contained in the first 6 chapters that deal with the different stages in the formation of contract, its essential elements, its performance or breach, and the remedies for the breach of contract. The remaining chapters of the Act deal with some of the special contracts like indemnity and guarantee, bailment and pledge, and agency. The provisions of the Act do not affect any usage or custom that exists in certain types of trade and business. The Contract Act is not a complete and exhaustive code. It only deals with certain aspects of the law and with some of the special contracts. Contracts pertaining to partnership, sale of goods, negotiable instruments, insurance, bill of lading, etc. are not dealt with by the Contract Act but by separate acts. The law of contract affects every one of us in our day-to-day lives, and the purpose of this law is to ensure that what has been promised shall be performed. Law of contract creates rights in personam as distinguished from rights in rem. Rights in rem are rights against or in respect of things, and rights in personam are rights against or in respect of persons. A right in rem is available against the world at large. A right in personam is available only against particular persons. Now, what are the essential elements of a valid contract? According to Section 10 of the Act, an agreement made by free consent of the parties competent to contract for a lawful consideration and with a lawful object and is not declared void is a contract. There has to be an agreement between two parties, one making an offer and the other accepting it. Parties must intend to create a legal relationship. Parties have to be capable of entering into an agreement as regards age and understanding. The agreement should be supported by consideration on both sides, and the consideration has to be lawful. The consent has to be free. The object of the agreement has to be lawful. The terms of agreement must be certain and be capable of performance, and if it is vague, it cannot be enforced. The agreement should not have been declared void by any law in force. The agreement may be oral or in writing, and where it has to be in writing, It must comply with the formalities as to writing, registration, and attestation wherever necessary. Now, coming to classification of contracts, contracts can be classified on the basis of their validity, formation, or performance. Classification according to validity. Contracts can be classified as void, voidable, illegal, or unenforceable contracts. Voidable contracts are enforceable at the option of one or more parties and not at the option of the other. Void contracts are contracts which cease to be enforceable by law. Void agreement is an agreement which is not enforceable by law and does not create any rights or obligations. An illegal agreement involves violation of rule of public policy or which is criminal in nature or immoral. Unenforceable contract cannot be enforced in a court of law because of some technical defect. Now, coming to classification according to formation. Contract can be express or implied. Express contracts are contracts where terms of the contract are expressly agreed upon at the time of formation of the contract. Implied contracts are implied from the acts and conducts of the parties and not as a result of any express promise by parties. Quasi contracts are created by law and are based on the principle that no one should be unjustly enriched at the cost of another. Now, contracts can also be classified according to performance as executed, executory, unilateral, and bilateral contracts. Executed contracts are contracts where both the parties have performed their obligation. Executory contracts are contracts where both the parties have not yet performed their obligation. Unilateral contracts are contracts where one of the parties has to perform its obligation. Bilateral contracts are contracts where both the parties have still to perform their obligations. Now, all these aspects will be dealt with in detail in other presentations. Thank you.